This document, I just dropped it in the chat. It's a good document to start out with if you're new to this. I'm gonna just read through it. It's about 18 pages, but it's a quick, understandable read. You can download it as well. And when we get done reading, we can talk about it. This is being recorded too, but you can record as well, and we can talk about it. Okay.
All right.
Okay. I had to pause, Billy and Mandy. You are speaking to a sovereign political power holder. I do not consent to you detaining me. Why are you detaining me against my will? That's the letterhead. That's the I think that there's there for a couple pages, so we really don't have to worry about that. The document explains itself throughout. The official state office known as person. This is the single most important lesson that you must learn. If you spend an hour to learn this material, you will be rewarded for the rest of your life. If you should discuss Hale v. Hinkle with a run-of-the-mill attorney, he or she will tell you that the case is old and that it has been overturned. If you ask that attorney for a citation of the case or cases that overturned Hale v. Hinkle, there will not be a meaningful response. The outlaws, meaning probably like some of us, some people that that have been on this privacy thing, outlaws have researched Hale v. Hinkle, and here is what they found. We know that Hale v. Hinkle was decided in 1905 in the Supreme Court. Since it was the Supreme Court, the case is binding on all courts of the land until another Supreme Court case says it isn't. Has another Supreme Court case overturned Hale v. Hinkle? The answer is no. As a matter of fact, since 1905, the Supreme Court has cited Hale v. Hinkle a total of 144 times. A fact more astounding is that since 1905, Hale v. Hinkle has been cited by all of the federal and state appellate court systems a total of over 1,600 times. None of the various issues of this case has ever been overruled. So if the state, through the office of the judge, continues to threaten or does imprison you, they are trying to force you into the state-created office of person. As long as you continue to claim your rightful office of sovereign, the state lacks all jurisdiction over you. And this is going for any situation, and that's really what I'm getting you to do. Understanding how to apply the level of sovereignty in whatever situation. Like I went to court today, and that I went in there and I didn't even say, I said one word, and that one word was yes. And she dismissed the case. Now, see what this is the preset for that. Let me go ahead and tag where I'm at, because I forget. But I misplaced my license here in North Carolina, and I went and ordered one online, and I printed out it's a pictureless document that they give you for like confirmation. So I printed that out, and I endorsed it, because like on the back it'll have a place where it says like endorsement or something on your ID or your license. It has the same place on that document that I printed out. So I put up under that endorsement line, I said all rights reserved, right? And then I signed it. I signed a special deposit, just in case I wanted to give it to the court, as a deposit. I just signed a special deposit for the case, and then I put my sovereignty name on there, and then my autograph or my signature. I went into court today, and first one in line, first in time, first in line type thing. And she introduced her legal assistant and stuff like that. She said a legal assistant can't, dismiss no cases or whatever. So I took that and I was like, okay, so that's the clerk of the court right now, because it's different roles that everybody in the court play. You got the clerk, you got the assistant, you got the one, usually one or two attorneys, or and then a judge. And then any opposing attorney, which would be like a defendant's attorney, would be the extra attorney in there. So when I walked up to her, I just had that one little piece of paper, and I slid it to her, and she just read it because it was it's an idea at the end of the day. So she read it as it should, and she folded it up and she put it in the little file, and she told me to sit down in the first row. Boom, I went and sat down in the first row, and when they called me back up, I don't necessarily, I know a lot. I learned a lot about the procedure and how to look into the different rules of the court. So different rules and things, because people on this journey, they tend to get some information and learn a lot, and then they try to avoid voice their knowledge it prematurely to really understanding and knowing what they supposed to know in the first place. So uh when they do that, it can be seen in a belligerent connotation, so they can deem that as trying to alert the public, being contemptuous or something like that in any way. So to avoid that, I just go in and I ask simple questions that even if I don't get the case dismissed today, I'm going to learn something, and they're going to understand what I'm trying to learn at the same time. So that's how you get to see a lot more and experience a lot more in the private, using these private things. You got to give things time to marinate on you and for you to understand it fully, because it's just it's the excitement of the public that gets us so happy to voice this type of knowledge so quickly before we fully understand it. So I went in there and I slid her the thing. She folded it up. She put it in my file. And when she called me back, she pulled it out. They do that, that turnaround real quick. You look at front and the back. Yeah, I got a stamp on the back of it. That's for different reasons. We can go down that rabbit hole one day. She looked at both sides, and she said so is because taxes are for your vehicle, or registration and for your vehicle, and a replacement, a confirmation for a replacement identification card, or a replacement for a license looks totally different than the confirmation you would get for paying your taxes, right? So she said she looked. We met eyes, and it was a certain way that she looked at me, and she said, "So is this what you so you paid?" I said, "Yeah." She said, "Okay, I'm gonna dismiss everything, because it wasn't nothing but a driver no seatbelt charge and uh dead registration. But see, this the process for all of that though. It's being presumed and assumed, something called being presumed and assumed by the courts, that we are operating in this office of person right here. So when you want to address things in your life, like credit reports, discharge, and things, stepping into court, or even trying to operate in court, filing a lawsuit or something like that, you want to make sure that you are in your proper capacity to begin with. Being in your proper capacity will set you off on the right foot every time. And understanding how to operate in that capacity will help you not to do something called breaking character, which is something that is easy to do when trying to operate in these private channels. So let me continue. But yeah, that's just one. It's a quiet. It's not meant to be public. Like when we win quietly. We give our rights, because our rights aren't. It's like being exploited. We don't want our rights exploited, but at the same time, we want them. You know. and we want to express them as well. So let me go ahead. The state needs someone filling the office of person in order to continue prosecuting a case in their courts. It's in the game. A few weeks in jail puts intense pressure upon most persons. Jail means the loss of job opportunities, separation from loved ones, and the piling up of debts. The judges will apply this pressure when they attempt to arraign you. When bought in chains before a crowded courtroom, the issue of counsel will quickly come up. That means they're going to try to assign you a public defender. And you can tell the court you are in propria persona, or simply proper, or most courts they like to say pro se litigant. As your own counsel, or simply proper, as your own counsel, and you need no other. Do not sign their papers or cooperate with them, because most things about your life are private and are not the state's business to evaluate. That is including when you want to file a lawsuit and they tell you, or you don't want to pay the fee, and they tell you to fill out this indigent form or whatever. It's none of their business. It's none of their business. Somebody came across a sovereign of this country, and the sovereign needs to be made whole again. That is something called equity. That is the way to think about that. Is like how in the Bible, you want to love your neighbor, how the Bible really intended for you to really love your neighbor the same way you would love yourself. You would never put yourself in a predicament that you can't win. Why would you do that? And equity also helps you if you don't know if you are gonna lose or not. It's legal maxims to this thing, but you got to understand it from a natural comprehension level. That's how you will be able to replicate and keep doing anything that you're doing. It don't matter what you're gonna do. Here is the sovereign people's command in the Constitution that the state respect their privacy. Right of privacy. These is found. You can go find these things. These are widely published. Every man or woman has the right to be let alone and free from governmental intrusion into their private life, except as otherwise provided herein. This section shall not be construed to limit the public's right of access to public records and meetings as provided by law. The federal constitution, that means the Constitution for the United States of America, or if you know it as the Constitution for the United States. But that is two different things. If the judge is stupid enough to actually follow through with his threats and send you to jail, you will soon be released without even being arraigned, and all charges will be dropped. You'll hear this a lot too in this space. A lot of that happens to a lot of people. They don't. It happens, but just because they don't know when and where to speak. I was a class clown in grade school. My first grade teacher, because I always had jokes. My first grade teacher was like, I know y'all like laughing at Takeem or whatever, but it's a time and a place for everything, because that's my business name, Takeem. That's my given name. That's my government. And Takeem, but he don't know when to play and when to go to work. I'm like, damn, he just played me like that after giving me a compliment. But it just happens because we gotta know when the oh, like that song. You got to know when to hold them and when to fold them, when to walk away and when to run. That song right there. it's a certain type of vibe that you have to be on to even want to understand this type of thing. When I got into this, I wasn't running from anything. I had a case, but I wasn't trying to, hop on this case using this stuff. And it wasn't no detrimental case either. I had just got another traffic case. They took my paraphernalia. Oh man. The next sentence right here.
You wild for that one.
Yeah, they took my stuff, man. So but when I went to court for that, they waived that and gave me a non violation, fee. But I had just got into this stuff, so I didn't want to burden myself with, trying to use it, and I didn't understand it. So I just paid the fee, and I do things every day, like sending things to, the judges and the mayor, just in the the attorney generals of the state or the county or whatever like that. Just letting them know, my standing, and I have my subject matter. You gotta let them know who you are without even having to be in anything. That way you already have your subject matter uh, jurisdiction established, and that'll help a lot, for real. Because if you give them a piece of paper, it's kind of like presenting your insurance card on your phone. If you don't have it in the car, it's the same type of thing, that you have that personal right to some kind of leeway to be different, you know. Uh, but let me continue here. You will then have documented prima facie grounds for false arrest and false imprisonment charges against them personally. It's key to get these people names and stuff too, because when we send this stuff to the the corporations and the banks, the CRAs, and just any other corporation, we want to be direct in our attempts and make sure that they know who we talk to. Now that you know the hidden evil in the word person, try to stop using it in everyday conversation. Simply use the word or the term man or woman. Train yourself, your family, and your friends to never use the derogatory word person ever again. Now, this is going to come not easy. I mean, it's easier to say people than it is to say man or woman. This can be your first step in the journey to get yourself free from all state control. It's a word game. We understand. Did you know that it's a word game? Because it's a word game out there. That's all it really is. You got to know how to speak your words, how to voice who you are.
I've been learning that literally every day for the past, I want to say maybe going on 3 years now. That is all a word game.
Yeah, and that's another thing that is good to get into is like grammar, sentence structure. I ain't gonna say, like what David, you probably heard of David Wynn Miller, but sentence structure and stuff like that, how to get points across on a document quickly, efficiently. That is something good to get into. Like I got this uh like it's like a little pamphlet. I got it from Office Max. It's like a little pamphlet on grammar, right? It tells you about
Uh huh.
commas, when to use commas, colons and stuff like that. How to
Mm-hmm.
adverbs, verbs. It's just it's what we learned in school. It's just recapping on the key points of getting your point across without sounding crazy. I
Right,
think I
but you know what's so interesting about this space is the fact of what we're learning now versus what we learned about in school. Like, yeah, we had the grammar classes and they showed us, all the specific grammar, what to utilize, but they never told us how to utilize it in this space. So it was like a broken knowledge.
right. It's like learning that the Apocrypha was part of the Bible or something for some people.
Right.
But let me continue. Hello, Rose. I see you popped in. Glad to have you. I'm just going through, a couple pages of this document now. I'm gonna go through it, and then we're gonna talk about it at the end. If I can ever just, stop trying to get somebody to understand, but I'm pretty sure you guys understand. I just want to read this document get just to remind everybody that it's a word game out there, and that's what we're trying to understand, how to use our words to express our rights in the way that it'll benefit us every time the right way. All right, so let me just continue here. Right here. The official state office known as person. What's up, brother Jason? I see that message too. Nice to have you, brother. This is the single most important lesson that you must learn. If you spend an hour to learn this material, you will be rewarded for the rest of your life. The word person in legal terminology is perceived as a general word, which normally includes in its scope a variety of entities other than human beings. See, for example, 1 USC Section 1, Church of Scientology v. U.S. Department of Justice, 1979. If somebody want to go look that up, post whatever that judgment was in the chat. That will be for all of us. One of the very first of your state statutes will have a section listed entitled Definitions. Carefully study this section of the statutes, and you will find a portion that reads similar to this excerpt. Construing these statutes in each and every word, phrase, or part hereof, where the context will permit. The singular includes the plural and vice versa. Gender-specific language includes the other gender and neuter. The word person includes individuals, children, firms, associations, joint adventures, partnerships, estates, trusts, business trusts, syndicates, fiduciaries, corporations, and all other groups of combinations or combinations. Note, however, the definitions statute does not list man or woman. That is very key to the word game. That's why, most of the people that you probably come across, if they really on something true, they'll tell you to go look into the definitions, and you'll get a lot of understanding with the definitions. I'm talking about when I first got into this thing, I had my law dictionary with every piece of paper that I read that came into the mail or came from the court. I was understanding, four corners law, four corner rule. Yeah. It's all, I got a document called Stamp Duty. It's a really good document to understand excise tax and how they portion that off from the beginning of stamp duty in the US. I don't think I'll drop that because I didn't feel like that would be up to date enough, but I can definitely bring everybody up to speed on that too. But let me continue here. Under the rule of construction, expressio unius is exclusio alterius, a rule of construction applying both to statute and legal writings that states that one thing having been mentioned, the other is excluded. Thus, following this rule, no dogs allowed means that lions are allowed, but guide dogs are excluded. It's like tit for tat. It's literally it's a technicality thing that people never love, never want to get into it about it. But everybody has to be. The law is always technical. Every case has to be very so very technical that if the signature at the end of the signature don't look the same as all the other documents they signed at the same time, it could be derived as forgery type technicality that we're dealing with. But outside of parentheses, where a statute or constitution enumerates the things on which it is to operate or forbid certain things, it is ordinarily to be construed as excluding from its operation all those not expressly mentioned. Generally, words in a statute should be given their plain and ordinary meaning. When a statute does not specifically define words, such words should be construed in their common or ordinary sense to the effect that the rules used in construing statutes are also applicable in the construction of the Constitution. It is a fundamental rule of statutory construction that words of common usage when used in a statute should be construed in their plain and ordinary sense, which they don't do because they got words that mean different things throughout different articles. Every piece of the article of the UCC got its own definitions. Come on now. In my state. If you carefully read the statute laws enacted by your state legislature, you will also notice that they are all written with phrases similar to these 5 examples. Boom, they give them 5 examples. A person, a person, a person, a person, a person. Notice that only persons can commit these state legislature created crimes. A crime is by definition an offense committed against the state, right? It's always us v the state, right? If you commit an offense against a human, it is called a tort. Anybody know what a tort is? What's a tort, y'all? Let me see here. Tort. Tort legal meaning, because it got something to do with contract law. Common law claim of injury from man to man. Layman's terms. And we can still expound on that. Common law claim. Now, before there to be a claim, there had to be a contract to begin with. That's common law. And somebody or something happened. A breach. They call it a breach in regular contract. Which now one of the parties needs to recoup or be, repaired or is injured, which is usually called in most cases a default, which now one party of the contract is now entitled to usually like the same type of way that you owe your buddy, $20 after, it took you out for some drinks and he said he was kind of low on cash right now, but you just got him back a little later and, oh, my $5. You forgot about my $5 away from, so that's the kind of thing of like a tort. Broke the contract of paying me back. So now you gotta even out, you gotta balance out the account. But you taking too long to balance out the account. So now we have to go to a third party, which is the court, to adjudicate the facts. From man to man. That's the most private you can get with dealing with contract. Contract law and tort law are 2 bodies of law that deal with civil wrongs. Contract law deals with contracts, written, oral, express, and implied, and the consequences of breaching them. Tort law deals with harm or injury caused by one party to another, and the compensation for such harm. Contract law is based on the agreement between parties, while tort law is based on the common law duty to avoid harm. So if you go around messing with somebody and you hurt them, that's the part of the tort law that they are now entitled to a recoupment. Because if you'd have left them alone, they'd have been fine. But like they said, it's their job to avoid it, though. It's your job to avoid bad contracts, too. It's not just their job to avoid us. We got to use our gift of discernment to understand them and how they coming. I was at to the all right. Examples of tort would be any personal injury, slander, or defamation of character. So how does someone become a person and subject to regulation by state statutes and laws? There is only one way. You must ask the state for permission to volunteer to become a state person. You must volunteer because the U.S. Constitution forbids the state for compelling you into slavery. This is found in the 13th and the 14th Amendments. And that's correct. Section 1. Neither slavery nor involuntary servitude except as punishment for crime. Crime is when you tort someone or when you tort their property. Whereof the party shall have been duly convicted. They got to have evidence that you did. Shall exist within the United States or any place subject to their jurisdiction. So the way they set up this what they call it, the workforce, is voluntary servitude. It's voluntary servitude. I would say we are franchisees of the federal jurisdictions because every year we file federal income taxes. Now, if you had like the State Department of Revenue instead of a Social Security number, then we would probably that would probably be state jurisdiction. But the fact that we get our federal, our numbers from the Social Security, yeah, we are federal franchisees. And to break that down a little bit more, we are franchisees because of a couple more things. Than like the ID and stuff, your license. We went and got a job, and that job uh leveraged your labor at a price that um you didn't know that you could actually negotiate. And then that job, gets paid for, paying you, and they charge you the taxes. The amount of taxes that you pay is the amount of taxes that somebody else is getting paid, or the company that you're working for is getting paid, right? So it's kind of like going to a bank, really, when you think about it, but instead of giving different collateral, you give your labor for the collateral, and the bank is giving you like an interest payment, or the job is giving you like an interest payment kind of thing. So it's crazy. It's crazy. 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction to equal protections of the law. You become a state-created statutory person by taking up residency with the state and stepping into the office of person. You must hold an office within the state government in order for that state government to regulate and control you. First comes the legislatively created office, then comes their control. If you do not have an office in state government, the legislature's control over you would also be prohibited by the Declaration of Rights section, usually found to be either section 1 or 2. I have not looked in my state's constitution. I don't feel like this. I learned the federal constitution. I recapped on that. It's just not my prerogative. I went down the financial route. I went down the trust route. I went down the underwriter route. I went down the accounting route. I went down the taxes route with reading them forms. But I already loved history, so a lot of the history that that everybody know, I loved that history. So I know a lot of history already. When it comes to how the money changed over and where it came from, where it started, and stuff like that. So that's just why I understand it as well. But there's definitely a lot of back down underground knowledge that is definitely needed to be uh, gotten with deeply understanding it. But when approaching it with, the spiritual understanding of equity, which is, harm no other, you can never just, you just can't be wrong. You can't go wrong with not trying to hurt nobody or get over on somebody. Can't go wrong with that. I'm also not, you got to be, ready and assertive, but not too aggressive. You gotta be able to, what they say, show your teeth in the right way without seeming belligerent, combative, and what's the other? What's the third one there? But yeah, you don't want to seem like a jackass or a heathen. Uh, the most common office held in a state is therefore the office known as person. Your state legislator created this office as a way to control people. It is an office most people occupy without even knowing that they are doing so. The legislature cannot lawfully control you because you are a flesh and blood human being. Now that's coming from when they be like, oh, they can't bring you into court, they can't be, dealing with the law of man and woman. This is where, that kicks in right there. This is where the dot connects. God alone created you, and by right of creation, he alone can control you. It is the nature of law that what one creates, one controls. This natural law is the force that binds a creature to its creator. God created us, and we are therefore subject to his laws, whether or not we acknowledge him as our creator. The way the state gets around God's law and thereby, controls the people is by creating only an office and not a real human. This office is titled as person, and then the legislature claims that you are filling that office. Legislators erroneously now think that they can make laws that also control men. They create entire bodies of laws, motor vehicle code, building code, compulsory education laws, and so on ad nauseum. They still cannot control men or women, but they can now control the office they created. And look who's sitting in that office. Us. We in that office right now. Well, not me, but I understand the capacity. I understand how I feel coming out of that thing. I went through so much headache trying to understand all of this stuff. I crammed so much information, it didn't make sense. I was always a reader, coming through school, but I definitely got out of reading when I got out of school. And to pick it back up, coming at it in a legal way, and it's business, and it has a way to tie into your spirit and understanding, it's a whole totally different feeling. Understanding that you can actually be financially stable on your own. You can take the helm of your ship. You can be the captain of your ship. My captain, oh captain, my captain. What they say? What's that joke? For real. All of these little jokes that we grew up watching on TV and stuff, and the truth that we saw on these TV shows and these movies, and then to know that they were actually telling us stuff. They are probably less now, but more prominent in back in the day, more or less before I was born. Probably when my mom was a kid, when they were showing uh, the truthful shit, because that's the most interesting to watch. Somebody else go through this shit. The motherfucker on TV going through it, that's fine. That's the way they indoctrinated us to be okay with not owning anything and being fine with it. If it's on TV, it's fine. That's not a good way to be. You gotta think for yourself. It's not good to be as low as they say done drug us down as a people of the United States of America. It's not good. The state creates many other offices such as police officer, prosecutor, judge, etc. And everyone understands this concept. However, what most people fail to recognize and understand is the most common state of office of all, the office of person. Anyone filling one of these state offices is subject to regulation by their creator, the state legislature. Through the state created office of person, the state gains its authority, which is a power, which is authority equals power. The state gains its authority to regulate, control, and judge you, the real human. What they have done is apply the natural law principle. What one creates, one controls, without telling us that we have that same right too. They created until we know that it's for us, and at that point we can come and get it, because they shouldn't have created it in the first place. That's how they did it. That's the fraud in the shit. If you really understand what fraud is. Because fraud definitely means if you're trying to get money out of somebody going about it the wrong way. In that essence. That's what fraud means. So them buying my baby body when I was a baby, buying my soul and my the bottoms of my feet and my hair, and putting my explanation of me, my meets and bounds on a piece of paper called a birth certificate. That's fraud. Not telling me that I could then, turn around and recoup on that birth certificate, because at the end of the day, it's a state as well. That's fraud. That's a lie in its conception. To tell me that it's only for identification purposes. And then some places, when I do it for identification, it's not even identification. What is the best way to draw a complete separate distinction from the living man and the person? One thing that I saw very important was that power of attorney. When you have a power of attorney, in proper capacity, uh, it works wonders. You are already, separating yourself from the liability of that person. But as long as you remain, how you said, a man or a woman, instead of, I say things like um, uh, my person. I don't say things like that. I usually, one second. Yes, an affidavit of non-corporate existence or the live life claim. I mean, yes. I would never negate something if there, if it unless it goes completely against principle, right? So both of those could work if you operate and execute those in the correct way. Let me tell you how to do the affidavit of non-corporate existence. Okay, so initially with a case, you would file that in the case with that endorsed, certificate or citation. calling on, that interest, because the non-corporate existence is saying that I'm a man of a woman without, if you write that document correctly. I've templated both of those documents just to see which I would want to use, but I still came up with my own. But the legislature creates the office of person, which is a mask. They cannot create real people. Only God can do that. They can create the office of person. Well, read that correctly. But they can create the office of person, which is merely a mask. And then they persuade a flesh and blood human being to put on that mask by offering a fictitious privilege, such as a driver's license. The legislature has gained complete control over both the mask and the actor behind the mask. A resident is another state office holder as well. That's why they said, you hear some people say, "Oh, don't even, be a resident either." That's good. That's good that they're saying that, because it's not good to be a resident too. Because I think I read that in the UPU, a resident is still has some shape, form, or fashion, some kind of allegiance to wherever they call themselves residing at. So, if anything, you might want to be an inhabitant. An inhabitant is the most natural that I can find of a word that can mean us. Your legs, arms, your torso, and your feet. You know, yeah, that's a good one too. Yes, yeah. Some residents are attorneys, and they also are not persons. An attorney uh, is a state officer of the court and is firmly part of the judicial branch. We know this. The attorneys will all tell you that they are licensed to practice law by the Supreme Court. Therefore, it is unlawful for any attorney to hold any position or office outside the judicial branch. There can be no attorney legislators, no attorney mayors, no attorneys as police, no attorneys as governor. Yes, I know it happens all the time. However, this practice of multiple office holding by attorneys is prohibited by the Constitution and is a felony in most states. It's something like that. When I'm reading these types of documents, I look into. Um, uh, this is my third time reading it right now, but I would look into things like that. These things, finding out stuff like this would help in a case, because at the point of you wanting to read or understand a document or understand how to do something, it's the little things that counts. That it's the little things that mean a lot in most cases, because it's the little things that will probably send you down a rabbit hole, right? But there's ways to, I like to say rabbit hole, but it's not. I don't like to, fear monger or anything like that. So it's not really like a rabbit hole that you gotta go down. It's, just gotta do some research, do some good faith research, looking for the right stuff. And knowing what the right stuff is going to be up to you and up to your situation basis versus on, what you know already. If you want to know it, you'll know it. It won't take as long to understand it, because you'll be so accepting to whatever facts that you understand as a natural ability, with your gift of discernment. You'll be able to move forward and execute anything anyway. Uh, if you read further into your state constitution, you will find a clause stating this. Uh, the separation of powers, which will essentially read as follows. One second. I think I would believe that the gaining the separation is understanding that um, initially you are not the paper, and yes, we answer to that name, or yes, we that's our name, or our man or woman name is not the MY, or is not YOUR all cap. your name type thing. If you get what I'm saying, it's like very, very technical, and it's parallel to the way that we would think in a normal way, in a natural way. That's why it's kind of hard to, go in between the lines because they're so well knit together. That when we say that you're not a person, but you're a man or a woman, well, a man or a woman is a person. Indeed, is not. Technically, it is not, and that's the technicality thing with the operation of law, um, and understanding terminology, uh, because the terminology is what separate. Well, the spirit of the terminology is what separates the actuality of the reality. What is everybody else going to perceive versus what the energy allowed to be put down in the first place? It is everything is a medium of exchange. We'll understand that later. Um, my plan is to just go through everything that, um, briefly that everybody has, been through. Because I got a lot of documentation. We're not going, like I said, we're not going to be going through anybody's process. Yeah, I got a lot of things that I can tell y'all how to do. A lot of, direction I can give you, but we just won't name, a particular process name. It's just like you just want to be a free man and woman. That's all. It's not the man and key process. It's not, oh, we doing, this process. We are understanding the capability of exercising our rights. That's what we're really doing. And learning, understanding, comprehending how to take the reins while we're doing that without having to be like, oh, will you help me? Or even if you need to contract with somebody else to help you, you will know how to do that, properly. And that's what I want to get everybody to do. I don't need nobody following me. I'm not a teacher. Well, I am a teacher now, but I don't. We need to understand that there's a greater goal, which is to do it yourself and to do it for others that, upbring others that don't necessarily know. I want all of us to eventually be on some kind of thing where we're showing people how to do this thing, because we got it to such a deep and understood level that we can just sit down and write a 300 page or 400 page, letter, directing, a company to, do something like that. And it makes sense to the company and they calling you, the next day or the next, couple of days, trying to settle with you and things of that nature. Court, just you exercising your rights. And that will be simple. When you understand that, everything is exercising your rights. When you want to talk to the judge, you're going to be exercising your rights. When you want to contract with a company, you're going to be exercising your rights. So why not understand how to exercise your rights first? If you read further into your state constitution, you will find a clause stating this, the separation of powers, which will essentially read as follows. Branches of government. The powers of the state government shall be divided into legislative, executive, and judicial branches. No person belonging to one branch shall exercise any powers appertaining to either of the other branches unless expressly provided herein. Therefore, a police officer cannot arrest a prosecutor cannot prosecute a sitting judge, a judge cannot order the legislature to perform, and so on. Because these offices are not persons, the state will not, and cannot prosecute them. Therefore, they enjoy almost complete protection by the state in the performance of their daily duties. This is why it is impossible to sue or file charges against most government employees. That's not true. That's not true. It's just a service. It's something called a service of process. Nobody is above the law. You can sue anybody. If their crimes should rise to the level where they shock the community and cause alarm in the people, then they will be terminated from state employment and lose their absolute protection. If you carefully pay attention to the news, you will notice that these government employees are always terminated from their office or state employment, and then are they arrested. Now it's a common person, and charged for their crimes. Simply put, the state will not eat its own. Like, it ain't gonna tell on itself. So, I mean, he was able to do it while he was in that office. So I mean, the state had some kind of power he should have in the first place, right? For it to be a criminal action in the first place, because he shouldn't be delegated the type of power to be able to abuse, especially with dealing with, sovereign people or people that supposed to be sovereign, because we don't know we sovereign. So we out here running around asking them for everything, and then they get the chance to eat our securities and eat off of us, and still, what they call that, give us the penny for the dollar or whatever. Nah, that's there. I need the whole dollar back, and then give me the dollar that you made off of it too. It's just a searching of your rights, really. And you learn your rights like, here's a little list of them. Really, you got the right to discharge, for one. You got the right to set off. And then the enumerated rights in the Constitution. Boom. Just to give you a quick starter of rights, that those are the same rights that have a monetary value. I think I remember saying that they have a monetary value that can be leveraged for any amount because it's your right. It's your property. A right is property. Look at what's that? Copyright. It's a copyright. They got a right to the copies that people be making. That's why they can sue you. If you make a copy of my IP, I can sue you. Right. Right? I'm not saying that, but that's what a copyright is. Trademark. Trademark copyright. The reason all state residents hold an office is so the state can control everything. It wants to create every single office so that all areas of your life are under the complete control of the state. Each office has prescribed duties and responsibilities, and all these offices are regulated and governed by the state. If you read the fine print, I say this all the time, the fine print is pretty to somebody. When you apply for a state license or privilege, you will see that you must sign a declaration that you are in fact a resident of that state. That's a fact. Person is a subset of resident. Judge is a subset of resident. Legislator and police officer are subsets of resident. If you hold any office in the state, you are a resident and subject to all legislative decrees in the form of statutes. They call statutes. What is a statute? It's a decree by the legislature. And all residents are subject to that. Statute's not law. Statute not law. How is it not a statute? Because it ain't nothing but a decree. How they used to say it? I declare a decree that all information is true and correct to my best knowledge. That's how you sign. Make a certified copy at home. That's how you do that. But they will always say that we are free men. But they will never tell you that the legislatively created offices that you are occupying are not free. They will say all men are free because that is a true statement. What they do not tell you is that holding any state office binds free men into slavery for the state by contract. It's by contract. That's it. That's all we got, y'all. That's the only way we can be bound by anything. And then into slavery, I know we don't want to be in slavery. It's a contract. The license is a contract. They are ever ready to trick you. Excuse me, y'all. I'm gonna edit that out. They are ever ready to trick you into accepting the state office of person. And once you are filling that office, you cease to be free men. You become regulated creatures called persons, totally created by the legislature. You will hear free men mentioned all the time, but you will never hear about free persons. You can be a notary public. versus a public notary, which is still either I mean vice versa, or whichever one means the one that is, the private individual that is doing the notarization or the certification for people within the public. That's the one that you want to be, because that's the private. But if you want to be, the other one, which is operating in the public to, bring the private documents into the public, um, that would eliminate a part of your private status. I mean, it's just whatever name you would create as a notary, that's the name that would be um, subject to either taxation or regulation. That's all, not your whole entire life. They don't want your whole entire life. And whatever person is owned by that, whatever owns that person is paying that off or writing that off. So yeah, you will be totally fine even if you do want to create a person and be a notary with that person, or of that nature. You just gotta understand the steps that you would have to take. Um, you can go through that notary law for your state, um, and get, I guess, adequately familiar with it. Go through some things that would probably pique your interest, such as like how to file for it, or how to carry out certain bit, things like that, things of that nature, things that won't have you feeling ignorant if somebody asks you a simple question about it. Um, if you build your life in an office created by the legislature, it will be built on shifting sands. The office can be changed and manipulated at any time to conform to the whims of the legislature. When you hold the office of person created by the legislature, your office isn't fixed. Your duties and responsibilities are ever changing. Each legislative session binds a person to ever more burdens and requirements in the form of more rules, laws, and statutes. That means the 81 miles of law ain't nothing but the bindings of the man into a person. That's all. Think of being got a vine wrapped around you to a tree for years, and you start becoming part of that tree. Now let's say you stay alive and you uh, eventually depart from this tree. It'll make it very hard to depart from this tree if this tree is a part of your rib now. It's kind of like, that's kind of like how they're trying to make it when it comes to being this paper or being this man. And when I say this paper, I mean this person, because that's the only person that they have created, is the one on the paper. Most state constitutions have a section that declares the fundamental power of the people. Political power. All political power is inherent in the people. The enunciation herein of certain rights shall not be construed to deny or impair others retained by the people. So even if it sounds like they trying to get too much out of something, we still got rights over that. Notice that this says people, it does not say persons. It's another thing that I like to point out too. From the beginning of the Constitution to I'd say probably like the 10th, probably even like the 9th Amendment, it says we the people, and then it changed over. It literally changes over to citizen. Why? Why did it do that? It's that binding that I just said something about. It's trying to bind you to an agreement. Because we got amendments and agreements and stuff like that. And if everybody consent, that's what consent is. Ratification. That's a big word for consent. Got ratification, right? When they consent to it, they gotta, abide by that. A sovereign is private. Oh wait, let me finish reading that. This statement declares beyond any doubt that the people are sovereign over their created government. This is natural law in the natural flow of delegated power. A sovereign is a private, non-resident, non-domestic, non-person, non-individual. not subject to any real or imaginary statutory regulations or quasi-laws enacted by any state legislature, which was created by the people. Like, if you need more confirmation than that to just sit down and understand that you got the reins to your ship, I don't understand. I'm not getting it. When you are pulled over by the police, roll down your window and say, I do not condone and saying shit to the police. Don't say nothing to them. If you really want to do something, anybody seen Jeepers Creepers, I like the movie Jeepers Creepers. If you ever seen that movie, and when they do that little spin around in the car, and she walking up to the car, and he like real still, he not moving until she run away and get back in her car because he got to get what he need. That's how you got to think. Like, I'm not going to say nothing. I keep my hands on the wheel, my head forward, and my eyes straight, and my window up. I don't hear you, see you. Only reason I pulled over because I thought it was an emergency with the red and blue lights. So, I mean, I didn't know that he was going to be standing behind me, and I'm not required to respond to somebody knocking on my window. I don't know him. I don't know if his badge is real or not. That's happened many times. People pulling people over and they fake police and people get killed. No, I'm not one of them. But you got to know yourself to be able to commit to something like that, because people get so scared of what they don't understand that we created the government. We've been learning this since school. We learned this in school. I learned it. I don't know if anybody else learned it, but I remember they telling us that the people, banging that stuff in our head, and then I look at it like, damn, I knew I liked that shit for a reason. They used to want to, cheat on my papers and stuff like that because I used to love history. I didn't like nothing really but science, English, and history. Math, bullshit. Get the hell out of here. But then I learned about the number 9. So, I mean, I'm cool with the flower of life. So, I mean, I'm cool with numbers. So that's why I delved into accounting, to get to know that. Because it's very important to be one with the numbers too, because they are still symbols and they mean things, right? So it says, I ain't even gonna read what it says. Y'all can read it. It's big and bold. Now, the state office of policeman knows that it is talking to a flesh and blood sovereign, right? After you supposed to say what it says, say, right? The police, there's ways to say that without saying that. That's what I'm saying. All of that. You don't have to say that. Just don't say anything, because still, he might want to contest that you were sovereign. He like, okay, so where did you get the tag? And now you got a contract with him by responding because he asked you a question and you responded to him in the first place. No. Don't sacrifice your property. Don't sacrifice your body like that, which is your property. Oh, please step out the car. You're now under arrest. I think you're a sovereign citizen. I'm afraid of my life. No, don't sacrifice yourself like that. Do it, people. Oh, man. The police officer cannot cite a sovereign because the state legislature can only regulate what they create. And the state does not create sovereign political power holders. It is very important to lay the proper foundation right from the beginning. Let the police officer know that you are a sovereign. Remain in your proper office of sovereign political power holder. Do not leave it. Do not be persuaded by the police pressure of tricks to put on the mask of a state person. Why aren't sovereigns subject to the state's charges? Because of the concept of office. The state is attempting to prosecute only a particular office known as person. If you are not in that office, created office, in that state created office as person, the state statutes simply do not apply to you. Now, some people think that's silly, but that's a principle. Now, we already know that the legislature is, it ain't nothing but decrees, declarations and shit, trust documents and stuff, separate trust documents, agreements. If you don't accept that agreement, then what terms do you have to abide by? Understand that. Yeah, right, buddy. See you in jail. Okay. Yeah. See me walk out of court after I get this case dismissed after saying one word. Yeah. Why aren't sovereigns subject to the state charters? Because of the concept, the construct, and the what's another word? The inception of office of person. This is common sense. For example, if you are not in the state of Texas, then Texas laws do not apply to you. For the state to control someone, they have to first create the office. Then they must coerce a warm-blooded creature to come fill that office. They want you to fill that office. Here is the often expressed understanding from the United States Supreme Court that in common usage, the term person does not include the sovereign. Statutes employing the word person are ordinarily construed to exclude the sovereign. Wilson v. Omaha Tribe. Right there. That's an Indian right there. Boom. Okay. 1979. Boom. There we go. Look into it, things like this. You gotta get deeper to get you understand. Okay. So they're talking about uh certain things like rights in this document. Let me go see the court order or the judge's order or something like that. It's an opinion, but it's an opinion that moved the court. It is still an opinion that moved the court. It's what they call it, expert opinion at that point. That's all a judge order is. It's expert opinion on the facts. And the only facts they're trying to operate off of is statutes, the terms of the acts that they enacted, whatever state you're in. That's the only trust document they got to follow. That's their job to do that. They're going by procedure and statute, legislature. They ain't got nothing to do with that. That's why they don't really be knowing what most of the sovereign citizens be talking about, because them people is compartmentalized to a certain point where when they clock out, they are DD from Texas Laboratory. The idea that the word person ordinarily excludes the sovereign can also be traced to the familiar principle that the king is not bound by any fact of parliament unless he be named therein by special and particular words. They gotta pull him in. They gotta pull him in the spell correctly. You hear me? And that was a United States case. As this passage suggests, however, this interpretive principle applies only to the enacting sovereign. You hear that? You gotta enact yourself. You gotta enact your sovereignty. You gotta move in it. You gotta walk in it. You gotta live it. You gotta love it. It's the way of life. What they call it? It's a lifestyle. It's not a hobby. Living like this can never be a hobby. Furthermore, as explained in United States v. Heron, 20 Wall, 251, 285, 1874. That's old case. It's the old and the new. Especially if they ain't been, cited since. Like, yeah, use that. Bring it back up. Let's talk about it. Even the principle as applied to the enacting sovereign is not without limitation. Where an act of parliament is made for the public good, as for the advancement of religion and justice, or to prevent injury and wrong, the king is bound by such act, though not particularly named therein, but where a statute is general and thereby any prerogative, right, title, or interest is divested or taken from the king. In such case, the king is not bound, unless the statute is made to extend to him by express words. U.S. Supreme Court Justice Holmes explained, a sovereign is exempt from suit not because of any formal conception or obsolete theory, but on a logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. Even I had to read that twice. But on a logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. Right? Right. The majority of American states fully embrace the sovereign immunity theory as well as the federal government. See Restatement, Second of Torts, 895B, comment at 400, 1979. The following U.S. Supreme Court cases make clear all these principles. I shall have occasion incidentally to evince how true it is that states and governments were made for man, and at the same time how true it is that his creatures and servants have first deceived, next vilified, and at last oppressed their master and maker. The public is indeed a jurisdiction. The public is a thing. It is a thing. And yes, they have plenary power over the public. That's why the public is regulated. In the public, you have to have a license. Operate in the public, you have to have a license, social security number, uh, a vehicle instead of a conveyance or a, a carriage. Yes, it took some time for them for the way they did it, but it is definitely the reason. Because it's like the Congress has they have a power to, levy money, and being in the public is worth money. So they put that benefit of, oh, we will back you up if you, use us or have interest in us while you're operating here. And uh they they leverage that. We sell ourselves and they buy it for the smallest price we can understand at that point. You'll get that later. A state, useful and valuable as the contrivance is the inferior contrivance of man, and from his native dignity derives all its acquired importance. Let a state be considered as subordinate to the people, but let everything else be subordinate to the state. The latter part of this position is equally necessary with the former. That's why I didn't separate with the little colon or anything like that. For in the practice, and even at length, in the science of politics, there has very frequently been a strong current against the natural order of things, and an inconsiderate or an interested disposition to sacrifice the end to the means. As the state has claimed precedence of the people, so in the same inverted course of things, the government has often claimed precedence of the state, and like that's when they talk about when the United States got the what they call that when the state signed over power to the United States, and they they came over past the 10-mile jurisdiction of DC or whatever. Uh, that's what uh, when they signed over that stuff, inverted course of things. That's what happened. That's what happened. The government has often claimed precedence of the state. That's what it means. And to this perversion in the second degree, many of the volumes of confusion concerning sovereignty owe their existence. Right. Reclamation. All of this, all of that is adding up to delineation. Right. All of that, everything has a play in the way that everything is working now. And it's great to know a lot of the monetary history, and a lot of the legislature is coming from a lot of the war and the monetary history. That's where a lot of the rules that we operate off of are coming from. Trade, diplomacy, things of that nature. The ministers, dignified very properly by the appellation of the magistrates, have wished and have succeeded in their wish to be considered as the sovereigns of the state. This second degree of perversion is confined to the old world and begins to diminish even there, but the first degree is still too prevalent even in the several states of which our union is composed. By a state, I mean a complete body of free persons united together for their common benefit to enjoy peaceably what is their own and do justice to others. It is an artificial person. It has its affairs and its interests. It has its rules, it has its rights, and it has its obligations. It may acquire property distinct from that of its members. It may incur debts to be discharged out of the public stock, not out of the private fortunes of individuals. It may be bound by contracts and for damages arising from breach of those contracts. In all our contemplations, however, concerning this feigned and artificial person, we should never forget that in truth and nature, those who think and speak and act are men and women, of course. Is the foregoing description of a state a true description? No, it will not be questioned, but it is. It will be sufficient to observe briefly that the sovereignties in Europe, and particularly in England, exist in feudal principles. The system considers the prince as the sovereign and the people as his subjects. It regards his person as the object of allegiance, and it includes the idea of his being on an equal footing with the subject, either in a court of justice or elsewhere. That system contemplates him as being the fountain of honor and authority, and from his grace and grant derives all franchise, immunities, and privileges. It is easy to perceive that such a sovereign could not be amenable to a court of justice or subjected to judicial control and actual constraint. It was of necessity, therefore, that suability became incompatible with such sovereignty. Right. Therefore, the acts, otherwise known as the acts. I dropped this document in the coach channel. It's the last message in there right now. You can probably download that. It's a regular old PDF. It's not like one of them EPUB documents. Yeah, just click the other chat and you should be able to probably download it or something. It's in elementary principles. Yeah, that's where it's at. Besides, the prince having all the executive powers, the judgment of the courts would, in fact, be only monetary, not mandatory to him. Like they're gonna be monitoring him type thing, but not mandatory for him to follow their monitorization type thing. And the capacity to be advised is a distinct thing from a capacity to be sued. The same feudal ideas run through all their jurisprudence and constantly remind us of the distinction between the prince and the subject, the sovereign and the defendant, the man and woman and the person. No such ideas obtained here, speaking of America, at the Revolution. The sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, unless the African slave among us, maybe so-called, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Chisholm v. Georgia. I like to read the judgments on cases sometimes. There are many ways you can give up your sovereign power and accept the role of person. One is by receiving state benefits, another is by asking permission in the form of a license or permit from the state. And they keep bringing it back home like that because the separation begins within. You got to understand the separation. You got to understand that anybody operating an office always needs a license. Anybody doing some kind of practice needs a license. When you at home cooking, you don't need a what they call that for the food cooking people. The safe serve. You don't need the safe serve at home. You know how to be clean at home. But when you out in the public, you need some kind of licensure. Why would not the same apply when you get into your car? Why would not the correlations it be easily acceptable to, you don't need a license for anything else. You don't need a license to do anything else but drive. Unless, of course, you are in a practice that needs regulation and licensure, of course. But when you are a private man or woman, you are not driving. You are just going from point A to point B. I'm going here to there. That's it. But it's a mindset you got to have to understand that differentiation they got going on and how they try to parallel it so good and quietly like this that, like they said, they just basically just coerce you into something called the office of a person. We understand that, paper. That literally means that we are, staying steadfast in whatever comes in due course of the name. Not that that's a bad thing, unless you know how to do business. If you know how to do business, that's a good thing. You're getting paid. You know how to endorse, you know how to create your instruments, you know how to do all of that stuff. But one of the subtlest ways of accepting the role of person is to answer questions of bureaucrats. When a state bureaucrat knocks on your door and wants to know why your children aren't registered in school, or a police officer pulls you over and starts asking questions, you immediately feel the office of person if you start answering their questions. It's as simple as that. It's literally just as simple as that. No matter how hard you knock on the window or none of that. Even if you got the window down, you still ain't got to say nothing. Nigga pull you out the car, you ain't said shit. You ain't did nothing. Why the fuck you pull me over? And then you end up pulling me out the car and ain't said nothing yet. Nothing at all. I'm talking about nothing at all. Nothing. That's a right that you have that they can't impede on. It is for this reason that you should ignore or refuse to answer their questions and instead act like a true sovereign, a king or queen, and ask only your own questions of them. You are not a person subject to their laws. If they persist and haul you into their court unlawfully, your response to the judge is simple and direct. You, the sovereign, must tell him, I have no need to answer you in this matter. I understand my rights, or whether I understand my fictitious charges. And what it said, it's none of your business whether I understand my rights or whether I understand my fictitious charges. It is none of your business whether I want canceled. The reason it's none of your business is because I am not a person regulated by the state. I do not hold any position or office where I am subject to the legislature. The state legislature does not dictate what I do. I am a free sovereign man, which is a great way to say that, and I am a political power holder, as lawfully decreed in the state constitution at Article 1 or 2, and that constitution is controlling over you, not me. You must never retain or hire an attorney, a state officer of the court, to speak or file written documents for you. Use an attorney if you must, only for counsel and advice about their legal system. If you retain an attorney to represent you and speak in your house, you become non-compos mentis, not mentally competent, and you are then considered a ward of the court. You lose all your rights, and you will not be permitted to do anything herein. Anything that this document talking about, you ain't gonna be able to do it. I mean, and you can go back and get anything you need to, but you won't do it right the first time. No matter what happens, if you remain faithful to your sovereignty, the judge in the state may not lawfully move against you. It's very key to when we get into the negotiation part. If you remain faithful to your sovereignty, the judge and the state may not lawfully move against you. The state did not create the office of sovereign political power holder. Therefore, they do not regulate and control those in the office of sovereign. They cannot ascribe penalties for breach of that particular office. The reason they have no authority over the office of the sovereign is because they did not create it, and the sovereign people did not delegate to them any such power. When challenged, simply remind them that they do not regulate any office of the sovereign, that their statutes only apply to these state employees in legislative created offices. This sovereign individual paradigm is explained by the following U.S. Supreme Court case. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no such duty to submit his books and papers for an examination to the state, since he receives nothing therefrom, beyond the protection of his life and property. His rights are such as existed by the law of the land, common law, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. That's the case we was talking about earlier. Let us analyze this case. It says the individual may stand upon his constitutional rights. It does not say sit on his rights. There is a principle here. If you do not use them, you lose them. You have to assert your rights. Demand, stand upon them. Next, it says he is entitled to carry on his private business in his own way. It says private business. You have a right to operate a private business. Then it says in his own way. It doesn't say in the government's way. And it says his power to contract is unlimited. As a sovereign individual, your power to contract is unlimited, literally. In common law, there are certain criteria that determine the validity of contracts. They are not important here, except that any contract that will harm others or violate their rights would be. For example, contract to kill, no, that's not valid. Next it says he owes no such duty to submit his books and papers for an examination to the state. Since he receives nothing therefrom beyond the protection of his life and property, the court case contrasted the duty of the corporation, an entity created by government permission, feudal paradigm, to the duty of the sovereign individual. The sovereign individual doesn't need and didn't receive permission from the government, hence has no duty to the government. Then it says his rights are such as existed by the law of the land, common law, long antecedent to the organization of the state. This is very important. The Supreme Court recognized that humans have inherent rights. Rights that don't come from a piece of paper. Inherent. It comes from just being alive. The U.S. Constitution, including the Bill of Rights, does not grant us rights. We have fundamental rights, irrespective of what the Constitution says. The Constitution acknowledges some of our rights. And the amendment, 9 states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The important point is that our rights antecede, come before, and senior to the organization of the state. Next, the Supreme Court says, and his rights can only be taken from him by due process of law and in accordance with the Constitution. Does it say the government can take away your rights? No. Your rights can only be taken away by due process of law, which is what we are learning how to do as well. And in accordance with the Constitution, which is what we're learning how to do as well. I'll tell you, go read the Constitution sometime. Due process of law involves procedures and safeguards such as trial by jury. Trial by jury means inter alia. The jury judges both law and fact. Then the case says, among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under a warrant of the law. That means in all cases. All cases, even a traffic citation, you gotta get the magistrate to issue a warrant. We're not standing on that simple right because we are driving, so that gives them probable cause to search our vehicles. No, our vehicle, just because it's movable, does not mean that you can just search my vehicle. It's not even a vehicle, but we don't understand how it's not a vehicle, which is the technicality that they actually look at. It's my CAR. It's my car. They don't talk about no car, no statutes. It's a vehicle. There's different nuances and ways to, state your cases without, bringing it about the public and, operating correctly. You gotta understand the energy that's coming to you as well. Finally, the Supreme Court says he owes nothing to the public so long as he does not trespass upon their rights. The sovereign individual does not have to pay taxes. Now, that is not, yes, the man or woman can never pay taxes, but the person that we have been gifted with does, so we can, that makes it easier to understand in a certain mindset that it can be done with our sovereign signatures. We'll unpack that one day, right? If you should discuss held vehicle with a run-of-the-mill attorney, he or she will tell you that this case is old and that it has been overturned. If you ask that attorney for a citation for the case of cases that have overturned held vehicle, there will not be a meaningful response. The outlaws have researched held vehicle, and here's what they found. We know that held vehicle was decided in 1905 in the Supreme Court. Since it was Supreme Court, the case is binding on all courts of the land until another Supreme Court case says it is. Has another Supreme Court case overturned held vehicle? The answer is no. As a matter of fact, since 1905, the Supreme Court has cited held vehicle a total of 144 times. Fact, more standard is that since 1905, held vehicle has been cited by all of the federal and state appellate court system a total of over 1,600 times. None of the various issues of the case have ever been overruled. So if the state, through the office of the judge, continues to threaten or does imprison you, they are trying to force you into the state-created office of person. As long as you continue to claim your rightful office of sovereign, the state lacks all jurisdiction over you. The state needs someone filling the office of person in order to continue prosecuting the case in their courts. A few weeks in jail puts intense pressure upon most persons. This is good for Jason because this is what was at the beginning of the document. I noticed that it repeated, but it doesn't fully repeat, continuing down. But this is what it says at the top of the document as well. A few weeks in jail. Judges will apply this pressure when they attempt to arraign you. When brought in chains before a crowded courtroom, the issue of counsel will quickly come up, and you can tell the court you are in propria persona, or simply proper, as your own counsel, and you need no other. Do not sign their papers or cooperate with them because most things about your life are private and not the state's business to evaluate. Here is the sovereign people's command in the Constitution that the state respect their privacy. The right of privacy. Every man or woman has the right to be let alone and free from governmental intrusion into their private life except as otherwise provided herein. This section shall not be construed to limit the public's right of access to public records and meetings as provided by law. See Federal Constitution 9th Amendment. If the judge is stupid enough to actually follow through with his threats and send you to jail, you will soon be released without even being arraigned, and all charges will be dropped. You will then have documented prima facie evidence for false arrest and false imprisonment charges against him personally. That's in the rules of, service process, in the rules of civil procedure service. That part, that part of the Where do we go over the table of contents and service that explains how to do that in personal capacity when even doing it for the Attorney General? You can take the Attorney General to court of the United States. This can be simply use the correct term, man or woman. Train yourself, your family, and your friends to never use a derogatory word person ever again. Because these words, they're spells. We know they're spells, right? But even deeper than that, there are symbols. These letters are, they're formulated lines, made to look a certain way that we have grown or know to understand. Right? So with person, it makes certain vibrations. And it's a vibe when we are putting these words, certain words in certain lines called sentences, right? So that's what makes the word play so very important in even the court of law, even in everyday life, just you can feel energies, vibrations. This stuff is real, even down to the universal spirituality, Akashic records, things like that. All of that. Every human on this earth is connected to that, that type of information in some way, shape, form, or fashion. And once the world understands that, we can be, a happy place. Not that as, required by me, but I mean, it'll be a step toward the beginning of whatever they want to say is peace. Now, oh yeah, I read that. Person. The word person is a very general word and can be limited to the statutory rule of construction. Noscitur a socis. The rule of Noscitur a socis teaches that the meaning of a word in a statute may be determined by reference to its association of a word in a statute. Reference to its association with other words or phrases. The context is the context. In the light of the context, the word person should be interpreted to mean corporation or company. The meaning of doubtful words may be determined by reference to their relationship with other associated words. So what you say can and will be used against you in the court of law, because you can be thinking you're writing a very powerful document, but the way you formulated it, put them words on that paper, I mean, you probably canceled it out. To properly construe the term person, we must look to statutes and pari materia. That's the case. The ejusdem generis rule requires that general terms appearing in a statute in connection with specific terms are to be given meaning and effect to that extent that the general term suggests items similar to those designated by the specific terms. In short, specific terms modify or restrict the application of general terms where both are used in sequence. Under the rule of ejusdem generis, specific words modify and restrict interpretation of general words. What that means is general terms that we use every day are changed up, flipped around, using a rule of what? Exactly. The meaning of the general words includes every natural person, firm, co-partnership, corporation, association, or organization, are restricted by the specific word corporation. Corporation is defined in Black's Law Dictionary, 4th edition, page 409. Corporation an artificial person or legal entity created by or under the authority of the laws of a state or nation. See Black's Law 6C, which defines corporation as corporation, an artificial person or legal entity created by or under the authority of a state. An association of persons created by the state, the statute, as a legal entity. The law treats the corporation itself as a person, which can sue and be sued. I tell people this all the time. That's why when I read this document a couple times, I was like, wow, this is a very good starter on understanding the difference between who you are. You got three people, POPLE, operating this person. You got your spiritual person, you got your physical person, and you got your mental person. The mental person applies the emotion. The physical person signs the paper and puts the emotion on the medium. It does exchange. Your spiritual person tells the physical to do what the mental wants it to do. It's kind of like a reflex in how the Bible talk about living in the flesh versus walking with God. It's deep thought. It takes deep thought and you got to want to go down them rabbit hole, because when you yourself, you have the power to understand what rabbit hole you want to send yourself down. There's no if and or but about that. You don't know what you want to look at. Ain't nobody gonna have to tell you much. You start looking into the right stuff. You don't know you're looking into the right stuff because your spirit is gonna guide you. The Washington State Session Laws of 1937, Chapter 227, SB 256, page 1141, Section 5B, defines personal word company as being the same as it reads as follows. The word personal word company herein used interchangeably means any individual, receiver, assignee, trustee, and bankruptcy trust, state, firm, partnership, joint venture club, company, joint stock company, business trust, municipal corporation, association, society, or any group of individuals acting as a unit, whether mutual, cooperative, fraternal, non-profit, or otherwise. That's a mouthful. And that's the binding that I was talking about with the tree. And it make it very hard to unbind yourself after being in the tree so long. I'm telling you, you got to think of it so natural to understand how it correlates. It's just so natural that it's very parallel. In anticipation that the state will argue that there has been a change in the language of the statute under which this charge is brought, it is submitted that the change is inapplicable and ineffective to change the result required. I still need my remedy. As the previously existing laws control pursuant to the controlling rules and statutes article, whatever that Roman numeral is, section 1 of the Washington State Constitution states in part that all previous rights, actions, suits, preceding contracts, or claims shall continue as if no change had taken place. Right. No change had taken place. So whatever you responded to in that case that they responded to it, whatever you responded to stands before the change. The federal constitution also has similar provisions at 1 statute 122 and 2 statute 298, and bring forward and certify and exemplify the law in pursuance to U.S. Constitution Article 4, Section 1, 1787. That's the original one. Look that up. 1791. That's the next one that came after 1787. And the RCWs contain a similar provision at RCW 1.04.021 in construing the codes in Title 46. Then the codes themselves are merely prima facie evidence of the law as recognized in RCW 1.04.021. Rules of construction, prima facie law, 1950. The contents of said code shall establish prima facie the laws of the state of a general and permanent nature in effect on such date. But nothing herein shall be construed as changing the meaning of any such laws. In case of any omissions or any inconsistency between any of the provisions of said code and the laws that is immediately preceding this enactment, the previously existing laws shall control. Those statutes stand unrepealed, unabridged, and unaltered, and should be held to declare the law of the state. Citation right there. State v. Williams, 85 Wing, 2D 29, 530 page, 2D 225, January 1975. The court has no authority to abrogate by rule a right guaranteed by the Constitution. They can't try to diminish no rule about no rule that they trying to, write up a right that, is guaranteed by the Constitution. State v. Pamphlet, 150 Washington, 411, 273, P182, 1928. Our state Supreme Court's decision on an issue of state law is binding on all lower courts until it is overruled by that court. State v. Gore, CRRL. Yeah. Statutes not superseded. Nothing in this rule shall be construed to supersede existing statutes or subsequent amendments thereto. Right? And require that earlier statutes control. So this that's about that's the end of that document there. And that's about I think it's right there in the beginning, like no contract or every contract that came before the Constitution of the United States is still, has precedent over the, Constitution. That's that precedent right there. That's that natural law. I mean, whatever came before this and it's still enacting. Like that federalism law, that what is that? Name the corner, all of that old stuff that they call it repeal. Repeal don't mean nothing but move somewhere else. They might try to change the definition now coming up because a lot of people know what repeal really means, but knowing how to distinguish yourself will help you a lot with being able to something they call draft instruments and stuff. Hold on real quick. You're gonna go into a non-negotiable instrument first. A written instrument that 1 is signed by the maker or drawer. 2. Now all of these are on there. No, wait, hold on. Let me read the definition. A written instrument that is signed by the drawer or maker includes an unconditional promise or order to pay a specified sum of money, is paid on demand or at a definite time, and is payable to order or to bearer. UCC 3-104. This is Black's Law 8th edition. I think there's go up to 12 or 11. But I wouldn't doubt that it means the same exact thing now. Also termed negotiable paper or a negotiable note. Among the various types of negotiable instruments are bills of exchange, promissory notes, bank checks, certificates of deposit, and negotiable securities. Now, security is a very wide range. Letter of credit is security. Federal Reserve note is security. Contract is security, like we spoke on the other night. Like, basically anything you sign is security. Just about. If it's not like a simple like notice letter, it's most likely some type of negotiable or non-negotiable, or even like a non-negotiable. The bill of exchange is a negotiable instrument, and it can also be non-negotiable instruments too. Non-negotiable bills of exchange, but they definitely fit in every category too. Negotiable notes, negotiable order of withdrawal. That's a good one. Negotiable order of withdrawal. Negotiable instruments such as a check, available on demand and issued against funds deposited with a financial institution. Financial institution is somebody like the Treasury, um, uh, Federal Reserve Bank, where they holding, the birth certificate, or some place like that. That's what they mean. That's holding some type of funds because they have like a initial issue document. Right. Second, I can try to bring up a little document. All right. Draft the negotiation. Most times you can do it by hand. Yeah, it's still like a third party that comes in and just, I say, like a judge, and just issues the funds based on the instructions or based on what they call the facts. None of this shit is hearsay, man. Yeah, all of this stuff is applicable on the internet, applicable in authoritative documents. Yeah, it's applicable everywhere. You can find it. Nothing that I say will be conceptual in nature. It will always be founded on uh, law, experience, and exercise. I can't help the gurus lead the people down the rabbit hole. But everybody needs the consideration for their time. Let's make us a negotiable instrument real quick. While we have some time, we can get some questions in. This is just going to be a simple Word document on how to make it look. I mean, you got this video, so I mean, you can see what I clicked many, many times. And rewind, do all that stuff. Just yes, yeah, it's great. Let me go ahead and insert a little text box because it's not gonna be uh, it don't gotta be all extra and spectacular and stuff. Boom. Just I'll be trying to make it like the size of a check. That's really it. The actual size of a check. So just basically starting out like anything, we want to make sure that it looks like an instrument. First of all, it looks, it's regular to the ordinary course of business. That's what we trying to do here. We're not trying to come in as a sovereign. Oh, but my stuff look completely different than what you and your people are used to. But you're gonna get used to it because this is the way that I do business. I understand people in their level of understanding their sovereignty, but it's still ways to do things. But let me get into this thing. So first off, we want to know usually what date it is. Boom. What day was this transaction? Right. You can put a date on each side if it don't really matter. Okay, so now we got the date of it. You got the amount. How much was it? Right here. Like I just, we got the drawer. Usually up there in the top, with that's where the bank name be at. That's there the drawer. Of course, the name, not just got the drawee, which would usually your name probably won't be on the check nowhere. If you're paying somebody else through your bank type thing, but your name will probably be somewhere like this, like your mind you, it's all caps. I'm doing that, the uppercase, lowercase thing for a reason. That is, completely voluntary right now. So pay attention to that as well. And then usually the drawer would not have to, place who their secured party is, which is, the Federal Reserve. They wouldn't have to place the Fed Reserve right there. They don't have to do that. We don't have to do that either. Okay. When you're making a negotiable instrument, you don't got to do all of that extra stuff. You can put your name. You want to pay. Your name pays the amount. You got the numbers. Yeah. Oh yeah. This money sign is very important in something that they call negotiability too. Yeah. That money sign. Non-negotiable, negotiable. Non-negotiable, negotiable. Non-negotiable, negotiable. Okay. Let's make it non-negotiable, but it's negotiable within whoever is negotiating it within that non-negotiable jurisdiction, right? Okay. You get that. Boom. Then put the amount in letters, zeros. Boom. 0 over 1. If you want to do that. Sometimes it'll, put the little zeros over the one I feel like it's supposed to be. Sometimes it don't. That don't really matter. 2, whoever, the corporation. Pay to the corporation. You can't put, without recourse because you're the originator of it. I mean, you can't do that. The acceptor can do that. No, that's a no. No, don't put that on there. And for service, give a memo line. It's good. It makes it negotiable. Makes it for services. This is this is outlined in the UGC. It's just gotta make it simple. For people to understand. I don't want to sound too technical to everybody, and then they'd be like, "You're using big words and you're a gatekeeper because you're not trying to break it down to like an 8-year-old. 8-year-old ain't supposed to be doing this. Where the mom and the daddy at?" But pays amount to you can put without prejudice though. Without prejudice to these facts. I know that I owe this person. I waive what they say service. I waive service on this. You don't even got to send it back to get your money. Just ask me for it. I got you. Like that's what without prejudice means. Like when you do it like that with this word, coming up for services without prejudice, like I'm gonna do it. There is no nothing here that makes me not want to do it because that's with prejudice. There's something here that makes me not want to do it anymore. I think so. You can go without prejudice right there. And then of course the drawer has to sign it. Right, drawer has to sign that. Let me show you over here. Some people say like this side, like the right side, is the creditor side, and the left side is the debtor side. I don't get that deep into it because I do many things and it really don't really matter. Let me go over here again. Not necessarily like to put. I read a promissory notebook, Bills of Exchange by John. I think it's John Wesley Johnson. And he wrote that promissory notebook about other the negotiable instruments or something like that. I just put a date up under that. Books had to do that. That's been working. For me, here lately. Put a signature line. Never forget to put a signature line or autograph lines. We like the word autograph. I like the word autograph too, but I can't remember. I'm so used to the word signature. Autograph is just too short. I don't like my autograph everywhere you, especially if I don't know how to redeem it. Okay. But yeah, we get into the texting on how to do the redemption and stuff. I do know how to redeem it, but I'm just saying for people that don't know how to redeem it, but they want to use these words and not understand how to execute using these words. It's funny to me. Autograph, boom, line. I don't know why I put like right there. This video gonna have to be heavily edited. It's gonna be a couple days before this video come out, y'all. Sorry. Autograph line. I would like to put a date up under that too. Okay. Put a date up under that autograph line. Again, autograph it's what's the autograph it's just to show you. You got it's like 3 different ways. One is yeah, by agent. That's one, right? That's one. And then you can sign as an agent. Yeah. Okay. Um, or you can just, just sign a name really like uh cap uh A R or something like that. That mean the AR is hold on. I'm gonna skip something. Buy. You never forget that buy. That buy, yes. It ends off liability. The buy right there. That buy is very important. Um yeah, that's a negotiable instrument right there. That's it, y'all. That's it. Oh wait, yeah. Corporation. Oh, got the corporation name right there. If you want to say that name again, you can. But I mean, shit, it ain't not needed. That's all it really takes. I don't know why. I mean, it took a lot for me to understand that this easy, yeah. But I mean, what the fuck? It's not that hard to pass it off, man. It took me so long to get to this understanding because I would never go to a fucking Google for this shit. They would never give it up like this. They would never look this easy. They always gotta write all of that other stuff, trying to get somebody to understand who they are and all of this shit. And first of all, it's a check. It look like a check, but it ain't got no. It don't have no numbers on it. How do they think it's a check? Sway. How? They're not. They're not gonna think it's a check. They're already gonna, look at it totally different. They're gonna approach it different. And don't put no thing on numbers on it. Don't put numbers on your private checks. Don't do it. It's private check. Yeah. Don't put numbers on checks. This is for, whoever, this is video. I think I'm gonna post this one. I ain't put nobody information on that. The last one is only linked. It's unlisted, but whoever has the link uh, can get to it because we had had somebody else's contract. Now, one of my contracts, I don't care. I'll post my contract on YouTube, but gotta have some kind of approval for that type of thing. Don't see it. But yeah, there it is. You gotta make that. You can make this type of negotiation for anything. You can make it as a payment to attach with your mortgage document or a mortgage coupon and send it back as payment. You can even go all out. You can put something simple. You can put payment up there. It just really is simple, y'all. For yeah, I've done it. That's why I know like it's just dang on simple, and it blew my mind to know that it was a simple. I'm talking about I was so mad. I was so mad when I found out. I was so mad when I found out. But I was glad to. And when I was able to, of course, I don't walk in nowhere with this document. I would never do that. I would never do that. But when things started happening after I, start issuing, this type of instrument, it's a quiet instrument that still uh, can get things done. Because you know why? It's the autograph, the open amount, and instruction. From who? Well, well, we got like both of that, but from who? Right there. To who? This is the pay to the order of box. Y'all know where this sits at, right there on the check. No, it don't matter what kind of paper you print it on. It don't matter. You can print that on napkin paper if you really want to. That's just the thing about the napkin thing with promissory notes. That thing is really true. You can really write a promissory note on a napkin, and that is the asset. The napkin is now an asset. I think I remember hearing somebody say something about a man wrote a car had fell on him, and he was fixing the car or whatever, and in his dying, and while he was dying slowly, he wrote his last will on like the hood of the car, and that was as evidence that was prima facie. So yeah, it don't really matter what it's on. As long as that medium is transferred, that energy is transferred to that medium is now valued. Yeah, I'm gonna take a little 10-minute break right quick. Negotiable instruments. Right. So in oh yeah, I see you guys. Thank you. Um, when looking at different things like especially a mail item that has uh an amount on it, like a debt collector coupon or something like that, it's negotiable or non-negotiable uh, after you endorse it. Now, the endorsement make the document, of course. Uh, Hold on, this computer's dying. Oh, Shows you how to make the document, but you gotta know how to sign it. Now, I put the autograph line right there. Of course, you're gonna know you gotta sign the front. Yeah, you gotta sign the front, but you gotta sign the back too. I'm about to put the 3 different types of ways you can sign anything. You can sign it blank. Blank endorsement. Yeah. Uh, Special endorsement. Got restricted. Back to the dictionary. Let me see. Uh, Blank endorsement. Sometimes it's computer gets warm too. Oh, is it? Put an A. Oh, that was a good one. Negotiability differs from assignment, with which it has obvious affinities in at least 2 respects. In the first place, no notice need be given of the transfer of a negotiable instrument. And in the second place, the transfer of such an instrument is not subject to equities. Thus, whereas an assignor only transfers his rights subject to any defenses which could be pleaded against him, a transfer of a negotiable instrument to someone in good faith passes a good title, free from any such defenses. For instance, a person who receives a check in good faith obtains a good title, even though the check may have been stolen. It is not, of course, any document which has the attributes of negotiability. Only those documents recognized by the custom of trade to be transferable by delivery or endorsement are negotiable. Other documents can only be transferred by assignment. Backing. Endorsement. Wow. In the first place, then the payee, or person to whom or whose order such bill of exchange or promissory note is payable, may by endorsement or writing his name in dorso or on the back of it assign over his whole property to the bearer, or else to another person by name. An amendment to an insurance policy, a rider, an endorsement, your acceptance. Here it is. The placing of a signature, sometimes with an additional notation. That's the restrictiveness right there. Boom, the additional notations. Because if you already signed it, what is the need of an additional notation? On the back of a negotiable instrument to transfer or guarantee the instrument or to acknowledge payment. Okay. Boom. And the clever endorser can subscribe his or her name under a variety of magic phrases. The code specifies the legal effect of some of these phrases. Qualified endorsements without recourse limit the liability of the endorser if the instrument is dishonored. Restrictive endorsements, such as for deposit only, pay any bank, and the like, set the terms for further negotiation of the instrument. Their main purpose is to prevent thieves and embezzlers from cashing checks. Uniform Commercial Code 16-7 at 92-93, 4th edition, 1995. Accommodation endorsement. An endorsement to an instrument by a third party who acts as a surety for another party who remains primarily liable. See accommodation paper. Bills and notes. Letters of credit. Anomalous endorsement. See irregular endorsement. You got first blank endorsement. An endorsement that names no specific payee, thus making the instrument payable to the bearer and negotiable by delivery only. Also termed endorsement in blank or general endorsement. Collection endorsement. See restrictive endorsement. A conditional endorsement. An endorsement that restricts the instrument in some way as by limiting how the instrument can be paid or transferred. That's the dollar sign or the no dollar sign. An endorsement giving possession of the instrument to the endorsee, but retaining title until the occurrence of some condition named in the endorsement. Wordings that indicate this type of endorsement are pay to Brad Jones when he becomes 18 years of age, and pay to Bridget Turner or order unless before payment I give you notice to the contrary. Also termed restricted endorsement, or special endorsement. So irregular endorsement. It says see irregular endorsement up top up there. A regular endorsement, an endorsement by a person who signs outside the chain of title and who therefore is neither a holder nor a transferor of the instrument. Hmm. So a person can be a liar and sign the endorsement if they know what they're doing. So that's what makes some of these people not liable in their official capacity when we bring these things to them or to their desk. That's why we have to uh, make them look at certain things when we address them by using their names, right? Or their corporate names. An irregular endorser is generally treated as an accommodation party, also termed anomalous endorsement or full endorsement. See, accommodation party, cases, bills, and notes. Uh, Qualified endorsement. An endorsement that passes title to the instrument but limits the endorser's liability to later holders if the instrument is later dishonored. Typically, a qualified endorsement is made by writing without recourse or sans recourse over the signature. That means over top. Also termed endorsement without recourse. See, without recourse. Restricted endorsement. Restricted endorsement, endorsement that includes a condition. So that's the condition right there. You know, if she has worked 8 full hours on April 13th, or any other language restricting further negotiation for deposit only. Also termed collection endorsement. Special endorsement and endorsement that specifies the person to receive payment or to whom the goods named by the document must be delivered. Also termed endorsement in full, full endorsement. Trust endorsement, an endorsement stating that the payee becomes a trustee for a third person. Pay Aaron Ray in trust for Caitlin Ray. A restrictive endorsement that limits the instrument to the use of the endorser or another person. That's a good one there. Yeah. Unqualified endorsement. Unauthorized, I'm sorry. An endorsement made without authority, no power, such as a forged endorsement. Unqualified endorsement, an endorsement that does not limit the endorser's liability on the paper. It does not, for example, include the phrase without recourse. Unrestricted endorsement, an endorsement that includes no condition or language restricting negotiation. I mean, hey, you ain't gonna say nothing, they ain't gonna say nothing. It's legal advice at that point that they say something. Because now you don't open up a whole can of worms right here in the banker's room. Because what you're talking about, I can sign it and keep all the interest coming to me. Because why did you tell me that there was interest to this note? I didn't know that. What you mean by interest, banker? Hmm. Just, these certain questions that we got to ask ourselves. Anybody have any questions? Anybody have anything they want to ask about, talk about? We're in the last 15 minutes of class. We got the open floor. Does a bill of exchange need to be submitted with the letter of advice? If the bill of exchange does not do the work that is intended, yes, the letter of advice is needed, but the bill of exchange should do the explaining of what's going on. There would be no need for a letter of advice. Just as, your bill of exchange might be bigger than this, but it's the same format that you need. It's the same format. One second. The same format. At the top, you put the date. At the top, you put your name, or your all caps name or whatever. Or your lower cap name and at the drawer, and then your name as the all cap name. The charge to or person paying. The other corporation, because they're two legal entities, so they can pay each other. Your energy is back in the BOE. Your energy is telling it. The energy on the paper is creating debt. I don't know how much simpler it can be with that. I don't know. What is backing? Is it you? You are literally backing the funds. You created the funds when you created the BOE. And they would be getting their funds from where you, using your BOE, direct them to get or submit the bill of exchange to for funds, which would be wherever your chain of title would start, or would have be like whoever the holder is of the master note of the bill of exchange. If you already lodged it somewhere, send them to where you sent your bill of exchange. But when you want to use your bill of exchange, if you want to use also a letter of advice, you want to make sure that your letter of advice is plain and simple. Plain and simple might be harder to achieve than you think, but I mean, easier to achieve than you think, and it can be done. It was just like that. Ever had boy, just like that. All of them notes. They're set up just like that. I always gonna need a date, maturity date, sign date, where it's going, who it's coming from. If you want to, you can. If you already got a lien on your person, uh, lien on your person or something like that, you can put the UCC number right there. Everybody got to know what it is. But put a number on there. You have to put UCC. Put a number on there. Then your numbers anyway. But security agreement between the man and all caps name. Yep. Yeah. Yeah. That would back the validity of the UCC. You can actually create a company and sue your person and get that judgment, just so you can be able to have a judgment for that lien. Uh, but that's another can of worms. I don't want to. YouTube, forgive me. Uh, I'm gonna cut that part out. But yeah, Jason, you heard what I said though. Um, your UCC one backs the bill of exchange. because there's some evidence of a value at least already had being exchanged, and that's what the UCC1 usually is. It's kind of like, it works kind of like a receipt. Any more questions? Would the claim of debt from the corporation be ledgered on the liability side of the ledger and then an equal amount on the asset side appears? Yep. Do you create the BOE for the exact ledger amount? Yes, sir, because the liability um, is it is a negative, right? And the asset side is the positive side, right? It's the cash on hand. The liability is whoever gave you that value you now owe, and the company now owes. So when the bill of exchange is created, it's coming from whoever the all caps name gave it to. So that's who would be furnishing that type of document back to the all caps name, and you will make it look as such. Yeah, no problem. Well, guys, I'm gonna be getting off of here and kind of edit this video, so probably gonna take a couple days. I'll probably do it maybe Friday, something like that. Um, and post that link for you guys. I'll get that link over to you whenever I get it edited fully. Y'all have a good night. Oh, if you have any more questions. Thank you. Wednesday, 6 o'clock.